Now, colleagues, we will proceed with the next item on the agenda, and that is the Commission statement on the adequacy of the protection afforded by the EU-US Privacy Shield. Madam Commissioner, you have once again the floor.
Mr. President, honourable members of Parliament, let me first of all thank you for the opportunity to speak to you today and to update you on the state of implementation of the Privacy Shield and our plans for the upcoming first annual review. Today's discussion is very timely as I have just returned from Washington and can inform you of the latest state of play. As you rightly note in the motion for today's resolution, the Privacy Shield has attracted a lot of interest, with more than 1,900 companies that have been certified under this framework. This shows the importance of the instrument for our transatlantic relationship. It also means that an increasing volume of the personal data that is transferred across the Atlantic benefits from the many protections that the Privacy Shield offers for individuals. I know that some of you had hoped for more, and I too would one day like to see a fully fledged, comprehensive data protection law in the United States. But in the meantime, our assessment is that the Privacy Shield framework lives up to the requirements of our data protection laws as interpreted by our highest court. Our highest court has clarified adequacy does not mean that the rules in the third country have to be an exact photocopy of our rules. Rather, what the Commission has to assess is if that third country offers in law and practice an essentially equivalent level of protection to that guaranteed in the EU legal order. Clearly, the Privacy Shield is a substantial improvement when compared to the old Safe Harbour. This is the view of our data protection authorities, and I am glad to see that your motion contains the same clear statement. However, putting in place the Privacy Shield framework, the privacy principles, together with the commitments and assurances by the United States government, was only part of the work. It is equally important that these rules also fully apply in practice. This is why our focus since the adoption of the decision has been on the effective implementation of this new framework. This involves several actors, and I am happy to report that our data protection authorities and the United States authorities have cooperated closely in working out procedures to ensure a robust oversight and enforcement of these new rules. Representatives from the Ombudsperson Office, as well as the Federal Trade Commission and Department of Commerce, have come to Brussels on several occasions to discuss with the Commission and the Article 29 Working Party the details of this cooperation and to report on their implementation work. During my visit to Washington last week, I put a particular emphasis on some of the key foundations on which the Privacy Shield is built. This concerns in particular the limitations and safeguards that apply in the area of government access for national security purposes. A central element of this is Presidential Policy Directive No. 28, which specifically addresses the privacy protections afforded to foreigners. Another key element is the Ombudsperson mechanism, which ensures that Europeans have a possibility to obtain an individual review if they believe that intelligence authorities have broken the law when accessing their personal data. And a third one is the Privacy and Civil Liberties Oversight Board. For the sustainability of the Privacy Shield, it is essential that these elements are part of it. We will closely monitor any relevant developments in the United States with a possible impact on the Privacy Shield, including the upcoming debates around a possible reform or prolongation of Section 702 of the Foreign Intelligence Surveillance Act, which expires at the end of this year. This is the message we have been sending since the start of the new administration. I have repeated this message during my recent visit to Washington and my meetings with the White House, the Commerce Secretary, the Attorney General, State Department, as well as Congress. And I received assurances that this message is well understood by our US counterparts, both as to the value of the Privacy Shield and the need to keep all of its elements in place. Let me make this point very clear. If we are faced with any developments that could negatively affect the level of protection afforded under the Privacy Shield, the Commission will take its responsibilities and use all available mechanisms, be it review, suspension, revocation, repeal, to promptly react. My focus is now on the first annual joint review. This will be a crucial moment, a moment of truth, where we take stock of how the Privacy Shield functions in practice and to see whether there are things that need to be improved. I have agreed with the US Commerce Secretary Wilbur Ross that the first annual joint review meeting will take place in Washington in September. All the various elements that are relevant for the functioning of the EU-US Privacy Shield will be covered by this review, inter alia. First, how US companies comply with their data protection obligations and the mechanisms they have put in place to ensure a speedy handling of complaints. Second, how the Department of Commerce and Federal Trade Committee certify companies, monitor compliance and cooperate with our data protection authorities in the enforcement. Third, the operation of the rules regarding access by public authorities and the rules and procedures to ensure that the Ombudsperson mechanism functions well. Fourth, in addition, the issues identified already in the Commission's adequacy decision, such as the dialogue on automated decision-making, as well as any developments in the United States law that might raise questions concerning the EU-US Privacy Shield and its operation, will have to be discussed. As partners in this review, we will of course discuss the precise parameters of the review with the Article 29 Working Party. The input from business and from civil society will also be of crucial importance. I met both sides in Washington and they are committed to contribute. On the US side, we expect the joint review to involve the Department of Commerce and the Federal Trade Commission, but also the Ombudsperson and representatives from the intelligence community. Directly after the joint review, we will report our findings to you and to the Member States in the Council. This will allow you and us to assess and discuss where we are on this and also discuss the next necessary steps. Honourable members, thank you again for giving me the opportunity to speak to you today, and of course I stand ready to address any questions you might have. Thank you.
Merci beaucoup, Madame la Commissaire, de cette intervention, et je vais maintenant donner la parole au groupe. Tout d'abord à Monsieur Voss de la part du Parti populaire. La parole est à vous.
Madam President, Commissioner, it's extremely important that when it comes to our companies, our small and medium-sized companies and startups, that we give them legal certainty and legal basis, that we provide this when it comes to the transatlantic data transfer, to ensure that there is proper data protection. And I think this is something that comes together in the Privacy Shield. But I would have to say that we, i.e. the Commission, over all these past few years, in the terms of data protection, and also now in the case of the Privacy Shield, I think we have achieved quite a lot. But I don't think we'll ever get the 100% which other political groups in this House would like to see. But I don't think there is actually any reason at the moment to speak about the Privacy Shield in such negative terms. In the European Parliament in 2016 and in June, we had a motion for resolution on the free flow of data, and we adopted this resolution. And we also gave a positive assessment of the Privacy Shield. But right now, right in the middle of all of this, because we know this has been up and running since June, July of last year, and we know there's going to be a new report in September, and there may have been a reason to assess or evaluate this, but we don't have enough practical experience to carry out any kind of appraisal, and we haven't got that information. You yourself have highlighted the positive elements, and in comparison to the Safe Harbour Agreement, then this is an enormous step forward that we could not have been able to expect ourselves, and it goes beyond what we would be willing to give in our own member states. So I think it's useful to have this interface. We know that the interface with national security is always going to be difficult, but if we take a look at the transatlantic flow of data, both sides can benefit from this, and this is an ideal opportunity for both sides.
Köszönöm, képviselő úr, most pedig a szocialisták és a demokraták progresszív.
Thank you very much. On behalf of the Socialists and Democrats, I would like to give the floor to Mr. Moraes for 4 minutes.
Thank you, President, Commissioner. The purpose of this resolution, to be very clear, is because we do have a September evaluation, and I really believe that the members of the Libe Committee, and indeed other members who have expertise and interest in this extremely important topic, need to give their views to the Commissioner. I don't see any problem with this. In fact, I think this is a positive and important part of our work. I want to begin with what you said about your trip to the United States. I think it's very important, Commissioner, that we, particularly for the Libe Committee, that we have an interaction with you before we in fact go to the United States before September. And why are we doing this? Why are we proposing this resolution? We're doing it not because with Privacy Shield there have not been significant improvements, key improvements on Safe Harbour, but because we want to ensure in the Parliament that Privacy Shield stands the test of time, that it doesn't have the weaknesses that would be difficult for the future. So we know that Privacy Shield protects fundamental rights of anyone in the EU whose personal data is transferred to the United States, as well as bringing legal clarity for businesses relying on transatlantic data transfers. And we cannot have that failing. So the resolution acknowledges that the final agreement on the Privacy Shield, adopted in July 2016, has taken a number of the European Parliament's concerns into consideration. And we know that the key improvements have been made compared to that former Safe Harbour. We note also that the agreement will facilitate data transfers from the EU to the US, particularly from SMEs and business in the EU, and that the EU Data Protection Authority's supervisory powers remain unaffected by the adequacy decision, including the power or suspension of banning data transfers to US companies, members of the Privacy Shield. We also take note of the clarifications and interpretations of the US administration, in particular as regards the processing of personal data by security agencies. However, several issues must be resolved. The resolution highlights issues of concerns that remain unclear, particularly, for example, made by the Article 29 Working Party, which, as we all know, is deeply involved in these matters. These include concerns regarding the principle of data retention, the bulk collection of personal data for national security purposes, the need for sufficient judicial redress, the effective independent oversight, as well as several law enforcement issues. If these concerns are not taken into account, the Privacy Shield risks not achieving its purpose and could face further challenge in the courts. And this is one of our deepest concerns. Both citizens and business relying on transatlantic data flows need that certainty of a robust legal framework, and this text calls on the Commission to conduct that proper assessment. It doesn't doubt that that will happen, but we are doing our job in ensuring that every part of this detail is covered. We will raise these concerns, of course, during our Libe delegation with our US counterparts, and we are now experienced in these negotiations. The Parliament has consistently called for a stronger agreement following the invalidation of Safe Harbour in October 2015. And we now want the protection of personal data which meets the requirements of the Charter of Fundamental Rights and the Data Protection Legal Framework. So, Commissioner, today we are calling on you to conduct a proper assessment to ensure this legal certainty is provided for citizens and business alike. We in the Parliament simply want to do our job. That is what the resolution is saying today.
Köszönöm, képviselő úr. Most pedig
Thank you very much. And now I would like to give the floor to Mrs. Helga Stevens on behalf of the ECR. You have the floor for a minute and a half. Thank you very much, President. Colleagues, first of all, I'd like to say that some of the member groups do not want to get the first evaluation of the Commission. I'm very disappointed about that. I'm also disappointed about the content of the Moraes report. I would agree with the others in the EPP that we need a better alternative. Let me point out one particular issue. The transatlantic data transfer is very important for our economy, trade, and safety. Nobody can deny this. And also, this is something that we should not move aside in this debate. We need, in the privacy shield, to think about the lack of security that may ensue. We need to reach an unprecedented level of data protection here. I think we're making some moves in the right direction, and we need to look at the transatlantic data transfer to the United States and make sure that we make progress there. We need to have the highest standard for data protection, but some political groups in the Parliament and some MEPs feel that this is just a copy of the European rules and this is enough. But the United States is an independent nation, and so we need to bear in mind that the U.S. is not a member of the EU, and so I believe very strongly that if the best way to protect our SMEs and our citizens is to have the best and highest privacy shield. Thank you. Thank you very much. And now I'd like to give the floor to Mrs. Innetveld for 2 minutes.
In reply to Mrs. Stevens, we're not actually calling for the suspension of Privacy Shield, but we do expect the European Commission to defend the interests of EU citizens and monitor extremely critically what is happening, because we have expressed very serious concerns already under the Obama administration, and for some reason the changes that have been made by the Trump administration do not alleviate my concerns. I don't know why. It's probably me. Indeed, we do not expect the US law to be identical, but we do expect it to be essentially equivalent, because that is what the judges have said. So that's not a party political request. It's an obligation for the EU institutions, and the European Commission is responsible here. I don't need to outline all the questions that we have put in the resolution. I'm actually a little bit disappointed. The resolution has been available in the public domain for some time now. I would have expected the Commission to already respond to the questions which are in there. What about the Privacy and Civil Liberties Oversight Board, which is under quota? What about the Ombudsman, who has not been replaced? What about the impact of Section 14 of the Privacy Act? What about the legal status of the assurances? What about the definition of bulk transfers? What about the interpretation of PPD 28? I mean, all these things the European Commission could have addressed in its intervention. I would really urge the Commission to not just repeat what should be done, but to actually be on top of things. That's the way the Americans would do it, so why don't we do it on behalf of our citizens? So, and two final issues, because it is not about party politics, Mrs. Stevens. There is a legal challenge before the ECJ. There's also the other issue, namely that national DPAs may actually decide to suspend the transfers, and then we have legal uncertainty. So it is not by asking critical questions that we create legal uncertainty. It is by not asking critical questions to the Americans. So, Commissioner, please make privacy great again. Thank you.
Thank you. The next speaker is Madam Ernst in 1.5 minutes.
Genau so ist es.
That's exactly right. With the Privacy Shield, we can't make peace. And we don't think it's an appropriate answer to the Schrems judgment either, because it doesn't offer the same data protection for all, because mass surveillance will be used for law enforcement. Huge flows of data will be sent to 16 authorities and are continuing to do so just like that. They can do that. This idea of an ombudsman is simply a fig leaf, because a lot of US organizations who want to take part in the Privacy Shield think that, well, they don't even have well, they've got that authority, but President Trump has said that he wants to exclude US citizens from that. So this Privacy Shield that we're talking about here is simply opening the door to all kinds of trampling of people's rights. And the US Senate and the House of Representatives has scuppered a ban that the telecoms supervisory control, well, the fact that internet providers, without agreement of their customers, can sell data, and that ban is going to be scuppered. So we support all the critical points put down in the resolution completely, because the problems have not been dealt with. Thank you.
The next speaker is Judith Sargentini in 3 minutes.
Mrs. Sargentini, 3 minutes.
Yes, you have the floor.
Dank u, voorzitter.
Thank you very much, President. The Greens understand that it should be possible for data transfers to the U.S. to exist. We have Facebook, we have WhatsApp, but sending personal data should not be at the cost of our personal protection. And so I do have some concerns about the Privacy Shield in its current form, because we don't have guarantees on the other side of the ocean. Many Americans say that there's a possibility of having bulk data being analyzed. So bulk data will still be able to be analyzed under Privacy Shield, and that's enough reason to reject this. And basically, it's because bulk analysis of data should be banned. And so, there are people who circumvented Safe Harbor in Luxembourg, but we all know that Privacy Shield means that our protection of data through Privacy Shield in the United States will be lower. It will not be the same. It will be lower. And there are people who traveled from Ireland to Luxembourg, and we see what happened with this, and so we need to think about how we negotiate with the Americans. The trade issues have been dealt with through the EPP and the ECR. They want to help the companies at the cost of our citizens, but we need to make sure that we have our friends on the right side. And And so this type of lack of protection is not good for business because a business will not be reliable. And so I would ask you to support our amendment, which puts a question mark on these negotiations. Thank you very much.
Reding képviselő asszony következik 1,5 percben.
Thank you very much. Mrs. Reding.
The question is simply, is the Privacy Shield stillborn? Vault 7 revealed that the CIA tapped directly into your smartphone. Microsoft and Apple court cases exposed the FBI tendency to bypass existing legal frameworks to access data. Congressional Review Act allowed Comcast, AT&T and Verizon to use people's data without their consent. And Trump's Muslim ban ordered agencies to exclude non-American citizens, not only Muslims, from their privacy policies. Now, all this has taken place after the adoption of the new framework, and all eyes are now riveted to the FISA Section 702. Dear Commissioner, do you really feel assured? Article 29 working group does not. Because yes, Privacy Shield has improved safe harbour. No, it did not assuage many of our concerns. The problem is and has always been the use of national security as blanket exemption. And this is one of the numerous questions that need answers, most of all during the upcoming review. Concrete evidence must prevail over alternative facts, legal obligations over written commitments, MEPs' demands over congressmen's promises. We must build a transatlantic digital bridge on a rock-solid privacy pillar, and unfortunately, I have the feeling that the shield might already have turned into a smokescreen.
Thank you. Thank you, Madam Reding. The next speaker is Madam Zippel. 2.5 minutes.
Yes, thank you very much. It was only once that the European Court of Justice declared the safe harbour system invalid that it was then that the Commission decided to take a look at better and clearer rules for data transfer to the United States. Despite some progress, however, the overall result does not convince me, because it is still very difficult to defend oneself against the abuse of one's data legally, because the ombudsman figure in the States is not unbiased enough. Are they going to be obliged to delete data when the data is no longer needed? But I think the biggest problem is that the new Privacy Shield does not rule out mass surveillance. In its ruling to render the safe harbour regime invalid, the Court of Justice said that the general access to the content of electronic communication infringes and breaches the main fundamental right of respect of one's privacy. As Social Democrats, we feel that what is important is that the various critical points be taken into account and that we do create legal certainty. The European Parliament cannot suspend the Privacy Shield. The Commission can, if there is too great a lack of legal protection. I feel it's a great shame that the Conservatives in the relevant committee were not able to support our joint resolution. It would appear that they feel it is far more important to have a swift solution for their companies rather than approaches which would guarantee greater protection, also in the interest of companies. And I would very much hope that we can get a majority for our joint resolution in plenary, because in this way we'll be able to send out a signal to the Commission, i.e. that the European Parliament is going to keep a very close and critical eye on the way in which the Privacy Shield works in practice. And if the result of this is that the Privacy Shield is not in line with the new data protection rules and the Charter of Fundamental Rights, the Commission would have to suspend this, because otherwise they would find themselves in a rather embarrassing situation that this Privacy Shield would also fail before the Court of Justice.
Képviselő.
And now I'd like to give the floor to Mrs. Anderson, for a minute.
Last year, some of us stood here and warned that the Commission's EU-US Privacy Shield agreement would not protect citizens' privacy rights, and how right we were. The so-called shield is an insult to citizens across Europe whose privacy has been further undermined. The agreement allows the US intelligence to carry out mass surveillance and collect huge amounts of private data and bulk information indiscriminately. It allows US companies to collect data on individual citizens every time they go online, with no effective legal protection, and it's only voluntary. It only applies to companies that have signed up. The rest can run fancy-free with our information, so this shambles breaches our fundamental privacy rights, and it needs fixed. It needs fixed urgently with a robust, effective and enforceable system that protects the privacy rights of citizens, not the interests of spooks and big business. And I would call on the Commissioner to fix it before the European Court of Justice forces you to do so for a second time.
Anna Gomes következik, 2,5 perc.
And now Anna Gomes for 2 minutes.
Na resolução sobre Big Data e direitos fundamentais que redigi e foi aprovada por este Parlamento no mês passado.
This resolution on big data that was approved, and we're living in the digital age, and we need to protect citizens in this era of new telecommunications. We must also protect data online and elsewhere. Of course, this principle applies to transatlantic data transfers. We need to have legal protection for our companies and for our citizens. Quite obviously, this means we need to have equivalent systems. The Parliament resolution recognizes that the level of protection for private life in the US and in the EU would require some type of improvement and clarification vis-à-vis the previous system, and the Commission has tried to make an effort to deal with some of the shortcomings that have been pinpointed by courts and elsewhere. Of course, there are certain reserves in terms of commercial access and access by public authorities of the United States. Let me give you a couple of examples. For example, the automated requests, the protection shield being in the hands of subcontractors, the lack of an ombudsman, lack of guarantees, the fact that we cannot guarantee that there would not be an attack on bulk data or analysis of bulk data. All of this has been brought before the courts. And of course, the situation in the United States politically is not the same. We cannot overlook the impact of the Trump administration on this agreement. It's not going to be the same as with Obama. Trump may not live up to the commitments of the previous administration. For example, he would like to pass a law that will allow companies to sell private client data to third parties without their authorization. So this doesn't really bode well for personal or private data protection. So I think we need to have an in-depth analysis of the shortcomings of the current systems, and we must verify the compatibility of what it will happen in the Trump administration vis-à-vis the previous administration on these issues. Thank you. And now I'd like to open the floor for the Catch the Eye segment. There are 2 speakers who've put their names on the list, but I do not see them in the chamber. Apparently, they have had other commitments. I'd like to give the floor now to Mr. Lopez Aguilar. Unfortunately, he's not here. And then Mr. Marias from the ECR, but he is not here in the chamber either. So without further ado, I'd like to give the floor to the Commissioner for some closing words.
Madam President, honourable members, I said at the beginning that I very much appreciate the opportunity to discuss here today, to answer your questions, to hear your views, because I think this is the important moment between the moment we started the full functioning of Privacy Shield and the first annual report, which will come as late as in September. I am grateful for hearing your views, also the critical voices, because we take all of them very seriously. Many of them we share, and that's why, as I said also at the beginning, we are closely monitoring the situation in the United States. It is not true that we only say what should be done. I am just informing you about the things we are doing, and this is something I want to emphasize very strongly. I am aware about the fact, and this was said clearly by Mr. Moraes and Mr. Voss and some others, that still, or at this moment, we still do not have any full assessment of the functioning of Privacy Shield, because this is just at the beginning. And that's why also for this reason I am glad about the idea which we discussed today with the chair of the LIBE committee, that I could come in the first half of this year to give full information about how we see and how we assess functioning of Privacy Shield. So this is my commitment, which I'd like to repeat here on the plenary. When I say that the first annual review will be the moment of truth, I mean it very seriously. This must not be just another report. I want to come with honest and true reflection of the situation. That's why I want to use all possible channels to have this full-fledged review, which will reflect how Privacy Shield protects the privacy of Europeans and whether it protects fully according to our requirement, according to the requirement of European law, according to the requirement of the court ruling. That's why I want to take all the inputs from the state administration, from the Working Party 29 on the European side, Federal Committee of Trade on the American side. I want to take on board all the critical comments from the NGOs. I spoke to both NGOs at European and American side. They are very critical. They share some of your concerns which you voiced here today. I want to create quite precise and detailed questionnaire which will be sent to the certified companies, the companies which have been certified under Privacy Shield, so that we receive information from them about the number of requests from the intelligence services and security bodies on the American side, and many other detailed information. I want to use also the media reports about the atmosphere and tendencies and trends in the United States to capture something which I call a real field, how to look at the situation in the United States. We must focus on three main things: on the legal environment in the United States, on the capacities which the United States, which the partners invest in full functioning of Privacy Shield, and on the way Privacy Shield is used and respected by the certified companies, and the way how Privacy Shield is used by the citizens themselves, because you know that important part of Privacy Shield mechanism is offering new ways of redress for the EU citizens. These are the things which we are going to focus fully and give the reflection of through the first annual review. Madam in 't Veld asked for specific answers on the questions. I will try to do it now, but as I said, we are ready to give you more detailed responses whenever you ask. On Ombudsperson, on P-Club, on Federal Committee of Trade, this is relevant, what I said before, that we are focusing on the United States institutions to be fully equipped as for the capacities and as for the responsible leadership to keep Privacy Shield running. We shared our concerns in Washington that we see these positions not that we do not see nominated or appointed persons on these positions. We have to face now the reality that the new American administration has to appoint still about 5,000 people to the senior positions in the state administration, out of which 1,000 must be also endorsed and authorized by Senate. And for instance, Ombudsperson is one of them, so we will have to deal and to negotiate now and monitor the work of the acting Ombudsperson. And my colleague spoke to this person. We are in contact and they understand how important this is for us. As for Ombudsperson, I will rely on the information for the review from Ombudsperson office because there should be not only the information about the complaints he or she received, but also the information about how many requests were sent from the intelligence services to the companies. I will push hard to get such information because we want Ombudsperson to act also as the relevant source of trustworthy information for us. On P-Club, similar situation. We urged the American side to have the full capacity of the committee, the same Federal Committee of Trade. I spoke to acting chair and we made it very clear that we are awaiting for the official new representation. On PPD 28, we have been assured that there are no changes foreseen. But of course, we will keep monitoring when we have our strong allies also in the Congress and among the experts who monitor the situation on this piece of legislation, which I made absolutely clear to American partners. This is the main pillar as for the American legislation for keeping Privacy Shield running. This is what we need to see in place and fully functioning. FISA 702, still no information can be received whether there will be amendments, whether it will continue in the way it is now in force. We have to follow all the information we will receive in the next several months, but I am rather skeptical that before the review we will have something more concrete about whether there will be some changes. I made very clear if there are changes to detriment and to worsen the situation for the protection of private data of Europeans, we will have to act, because this is absolutely crucial piece of legislation for Privacy Shield. On the executive order, this is a different situation according to our legal analysis, because the protections of the Privacy Shield are not based on the US Privacy Act. Therefore, this executive order, which you mentioned, has no impact on this. This is the executive order on enhancing public safety, and in its section 14, this concerns protections under the US Privacy Act of 1974. And the Privacy Act only applies to US citizens and permanent residents. The Obama administration had instructed federal agencies to use their discretion to apply these protections also to others in the context of migration databases, and this policy now has been reversed. But let us be clear, as I indicated, the Privacy Act never granted any rights to Europeans. That is why we had to negotiate new arrangements, notably the Umbrella Agreement and the accompanying Judicial Redress Act, to ensure necessary protection for Europeans, and these remain unaffected by the executive order. This has also been confirmed by writing by the United States. Let me conclude by saying that for us it was the main message to come to Washington with, that we see that in the United States the priority of security is very high. I made absolutely clear that for us the protection of private data of Europeans is a very high priority. It's a fundamental right which must be protected also when the data transfer to the United States. And this I think was well understood by all our key American partners. I want to say that the protection of private data must remain great, not must be made great again, because this was our message to our American partners. Thank you very much for your patience, and sorry for being that long. Thank you.
Köszönöm szépen biztos asszonynak a tényleg kimerítő és
Thank you, Commissioner. Thank you very much for your detailed replies. And we now will very much hope that the Privacy Shield will guarantee good protection, that it will work well. There are 2 motions for a resolution that have been tabled. And on that note, that closes the debate on this particular point, and the vote will be taking place tomorrow.